Ladies and gentlemen, welcome back. I hope you all had a pleasant coffee break. Without any more delays, let's just continue to our third session for today, Islamic views on international law and the making of international law in Indonesia. I'd like to invite Professor Tai Hyun Choi to the floor from Hanyang University School of Law, former president and current Society of International Law Korea. Big round of applause.
Good afternoon, everybody. From now on, we have the third session. As just introduced, my name is Tai-Hyun Choi, and I'm a professor of international law at Hanyang University in South Korea. At the outset, I would like to express my deep gratitude to the hosting institutions, especially the DILA Foundation and the Islamic University of Indonesia. Today, I'm very honored to be here as a chairperson with many distinguished scholars and foreign scholars in attendance. Now I invite the presenters of the third session. Originally, there were 4 speakers in this session, but as we heard morning, one professor is in hospital now, so it's very regrettable for Professor Nada Camille Ariaduno not to be present here. I hope she will recover as soon as possible. First, I invite Professor Agus Trianta. Please come over to the podium. Professor Trianta is the associate professor of Islamic University of Indonesia School of Law. The second speaker is Professor Dodik Setiwana Nur Haryanto. Islamic University of Indonesia. And the third speaker is Professor Christopher Casey. He is already famous among us. So, I don't need his introduction. As you already know, the general title of this session is Islamic views on international law, the making of international law in Indonesia, part 1. Nowadays, the development of international law is one of the most crucial issues, both in national and international arena, which we are confronted with, and we should attain the goal. So in this session, we will mainly focus on the process and contents of the development of international law in Indonesia. And this session also aims to explore and review the various legal issues which have been connected to the development of international law in Indonesia. Having said that, the 3 presenters would be requested to limit the presentation to maximum 20 minutes. Okay. The first speaker will be Professor Agustina.
Okay. Good afternoon, everybody. Assalamualaikum warahmatullahi wabarakatuh. I deeply grateful to chairperson who allow me to sit in front here for presenting my paper on the topic of Ihya al-Mawad, Islamic law perspective on the concept of land occupation in international law. So I tried to make the analysis, not really the comparison between Islamic concept on the land acquisitions with the international law perspective. And this paper, the author by written by one of the researcher in Center for Islamic Legal Study, Faculty of Law Universitas Islam Indonesia. Okay. The first point, I would like to briefly explain what Ihya al-Mawad. Ihya al-Mawad means it is a revival of dead, unutilized, or abandoned, or wasteland. It means the abandoned land, unutilized land. And Ihya means reviving, the process of reviving the abandoned lands on unutilized land. And as we know, that in international law, land acquisitions based on what we call the effective control. And the meaning of effective control, as far as I know, because my picture is actually Islamic law, and I struggle to understand some point of international law, particularly in land acquisition. And so please give some suggestion if in the aspect of international law I'm not really precise in presenting this paper. Okay, as regard to effective control, there are description that it's based what we call the occupation of territories on by non-territory. And this is as what stated by Grotius and also Judge of Harper in Island of Palmas. And another aspect of effective control is occupation of occupation or legitimization of a legally doubtful title by process of recognition, equitable, and passage of time. We go to second aspect that effective control has two elements. First, intention and will. Intention, the activities have been undertaken on behalf of the state and not private action, as has been clear from IGC concerning sovereignty, Likitan, and Sipatan Island, that we know that the authority requires demonstration of acts of administration and the execution of government function. So these two elements with Mawad in Islamic law. Okay. Oh, sorry, I didn't put this. Whereas I already described it just before, yeah. Okay. And now we go to the strategic land position in Islamic law. In Islamic law, it's clearly stated that there are very important positions of Islamic, I mean, of lands in Islamic law. First, it is land which was firstly endorsed by Muslim in the classical era, in the prophetic era, as the object of wakaf. Wakaf is donation, but especially for the intake object, that it's still intake after use for a time. And the only thing which is stated by Islam is land. And second, according to the classical Islamic law, that land also can be used as the conservation zone, which is in Arabic called as hima. Hima, it means protected. Again, Islamic law also stated that land can be object of leasing. We know that many objects can be object of leasing, but not all the objects. But particularly, land has been recognized in very initial step of Islamic law that it can be object of leasing. And again, it is becoming object which is must be utilized by the owner. And therefore, Islam strictly condemns any ignorance toward the land that belongs to someone. It means that the land must be utilized according to Islam. And the last, that condemnation of trespassing. It was stated very strict in the Islamic law that anyone who changes the borderline of land belong to the neighbor will be deserved for, for the very deep and very big sins in the hereafter. So this is the strategic position of land in the eye or in the view of Islamic law. We go to the next. And land acquisition procedure in Islamic law, first by sale and purchase, or in Arabic we call by al-aqd al-bay', and second by booty of work distribution. This is only happen in classical Islam. And third, by the grant from the government. It is stated in Islamic law that the government may grant any land to anybody because it by iqta. Iqta, it means the grant of land by state to any force or anyone who considered to be appropriate to be granted land. And number four, inheriting the land from the family, of course. And the last, by way of dead land or abandoned land revival. This is the the last one is relating to the topic which I would like to emphasize here. Okay, the next. The legality of Ihya al-Mawat. It is the reviving of the abandoned land in Islam. This is the statement of the Prophet. Whoever reclaims the land, it becomes his, and a transgressor sweat does not grant him any rights. In Arabic, originally the term is man amara ardan laysat lahu li ahadin fahuwa ahaqu biha. So a person who reclaims the land at the first, he has the right for that land. This is stated by Prophet. And second, another statement of the Prophet: whoever takes accessible property that was not taken by any other Muslim does own what he took. So this is very clear, the concept of the land acquisition in Islamic law, which was stated by the Prophet and implemented in the early stages of the development of Islamic law. Okay, the procedure of Ihya al-Mawat, or the land acquisition in Islamic law, first by watering the land, because if we come back to the initial context of the development of this law, actually we know that in Arabian Peninsula that there was the desert, and of course the first watering is a kind of process of utilizing land, and secondly fertilizing. So if someone owned the land and no one owned this, and try to fertilize the land, is becoming the owner, and the third cultivating, and the fourth creating fertilizer, and The last, building irrigation circling the land. Okay, now we go to the loss of the land ownership. Islamic law also constitutes some of points which becoming the element which degrade or which eliminate the ownership of land. First, by sale, this is very natural. I do not need to more on this. Second, inheritance. Third, wakaf donation. Wakaf donation is donating land. This is very famous in Islam, and I believe that in other religion or other tradition also available such kind of thing, though with the different name. But in Islam we call it as wakaf donation. This is someone donating the land, but the land must be used and cannot be returned to the owner. And the fourth, taken or deprived by the state. It was started in the early, in the classical Islamic law, that the government has 3 years of the deadline to determine whether the land can be taken over by the government or not. Because if the land is not utilized until 3 years, the government can take the land. This is according to the classical Islamic law. So someone who just have the land without, and the owners ignoring this, not utilizing this until 3 years, then the government may deprive the land. This is also enforced in the era of the many period after the prophetic era. And the last, not utilized or abandoned. Okay, we come to the conclusion. The way of taking possession of land can be attained by reviving an abandoned or unutilized land. This accord with the concept of the loss of land by abandoning it or leaving it unutilized. So it just, that this is the parallel, that the way of taking possession is by reviving an abandoned land, and this accord with the concept of the loss of the ownership, that if someone abandon or leave the land unutilized, the ownership will lose. And when a piece of land which is not owned by any parties, and this is owned by someone, be it natural or legal person, it is thus, in Islamic law view, the finder reserve the right to possess it. However, the finder of such a land must undertake necessary action to function the land for beneficial purposes. So whenever someone take the land, they must utilize the land for the proportional purposes. Otherwise, the ownership will lose due to the doctrine in Islamic law that any land belong to anybody which is not well utilized for at least 3 years will be taken over by the government. Because Islam condemned the ownership of land without utilizing it properly. Thus, the element of intention and will in international law as the element of the effective control can be put in the analogy to well utilizing land in the common function according to Islamic law. So, based on the whole of the point that I mentioned before, we see that there is some aspect of similarities between the concept of effective control in international law and the concept of common utilizing land in Islamic law. Also in the concept of land acquisition by reviving unutilized land in Islam and by claiming unowned land in international law. Okay, thank you very much.
I thank to Professor Agus Triansa, who is excellent and insightful presentation and keeping up with the time needed. I don't want to reiterate the detailed contents of the presentation, but to sum up briefly, it instructed us how the relevant Islamic law concept, that is, DILA is connected to the free application concept in international law. We conclude that the both concept is very similar in that the land not utilized or abandoned is subject to another application. So now it's the time to the second speaker. The second speaker will be Professor Lobi. No, sorry. Professor, please.
Thank you very much for the introduction. And I'd like to apologize, first of all. I'm very appreciative of the honor to be here. It's a little unfortunate. This opportunity. And I'd also like to say that I'm not expert in Islamic law. And so not Asian. And so I'd like to focus my presentation on what I've seen as a historical injustice and some of the progress that's been made to remedy that injustice. So first of all, I'd like to talk a little bit more about briefly my motivation, what sort of informed this paper. Second, just an outline of the research, outline of the paper, and then the findings, of course, briefly. So first, a couple dates. August 15th, 1945, Korean independence, celebrated on that day. August 17th, 1945, 2 days later, Indonesian Independence Day. And having celebrated Independence Day in both countries, I was very interested in finding out commonalities between Indonesia and Korea as it came to historical injustice. What I found out is selecting a subject for this research project, it's very difficult to find similarities between these two nations, even though their birthdays are only 2 days apart. Obviously, the population of Indonesia is very diverse. Over 430 languages are spoken. And different ethnicities, different religions, although primarily Islamic. And so Korea, as a more heterogeneous country, doesn't have similar injustices towards certain minority groups within the country, or at least not that I observed. And let me say right now, I'll plead ignorance on so many things. As an outsider attempting to do research on Indonesian law and Korean law, it's been an uphill battle. So if I misstate something, please forgive me. Please forgive my ignorance in that regard. So one thing, through my observations and through statistical research, I found that one group in both Indonesia and Korea have faced I guess we could say discrimination or historical injustice, and that would be a group of women in both countries. And of course, talking about injustice against women can be the subject of volumes and books, which it is, as a matter of fact. So I really wanted to focus on employment discrimination and the effect and how to gauge whether there has been success over the past decade in gender discrimination in both Indonesia and in South Korea. So I want to find out what is the history of gender discrimination? What are some recent developments? And then, of course, after this morning session, being the Westerner, I often find that I try to analyze culture and laws through sort of the ethnocentric lens of being an American. I tread lightly in that regard. But instead, I decided to go the opposite way and focus my research as basically applying an American law to try to determine whether or not there was success in eliminating or reducing employment discrimination based on gender. And so I discussed in my paper Title VII of the Civil Rights Act in America and disparate treatment litigation, mostly because that's my background. Then again, whether or not we can calculate the effect of any litigation or any legislation in South Korea and Indonesia. So in American law, there's two types of discrimination legislation. One is what we call disparate treatment, or based on gender, ethnicity, national origin, or religion. It's illegal to discriminate based on those things. So obviously, there's obvious discrimination where individuals are treated differently based on these criteria. And as an example, I downloaded I'll translate a little bit. Lowongan kerja, this is a job description, a job opening in Indonesia. It's for a computer technician. And one of the requirements, in fact, the first requirement, is that it's a Priya, which is a male, and that they must be a maximum of 27 years old. Which is, from an American point of view, this is prima facie discrimination. It's in fact the definition of age and gender discrimination. And of course, this would not pass muster in the United States. However, because this type of advertising, this type of discrimination is patently illegal, employers try to accomplish their same goals, the same discriminatory goals, but by sort of reworking it a little bit. So you can imagine to comply with anti-discrimination laws, we would delete item 1 from the job description. However, there's a second way in which putative plaintiffs can get recourse for potential discrimination. And that's what we call disparate impact. Disparate impact is where something is neutral, it's a neutral policy, but it has a discriminatory effect. And so, for example, in this past case, the second requirement was the requirement of education, level level 3 vocational education in computer science. And that seems perfectly reasonable on its face. A computer technician should be able to, should be required to have some education. However, if that has a negative and discriminatory impact on one of the affected groups, women, minorities, people who are over the age of 27, then that also gives grounds for basically a lawsuit to recover damages for gender or racial discrimination. So the way the case works, and something unique, I think, to litigation in America, or at least common law jurisdictions, is the burden of proof. And we call this the shifting burden of proof. And so, I apologize, the blanket is a little bit small. In order to prove discrimination, a plaintiff must only show that a neutral policy has a negative impact on a protected class. We call it the prima facie case. And that's all the plaintiff needs to prove to essentially put the burden then on the defendant. The defendant then must establish that the requirements for the job are a business necessity. And so the defendant there then has the burden to establish that not just business desire, but it must be a business necessity. And then the burden shifts back to the plaintiff to establish that this business necessity is just a pretext for discrimination. There's a couple examples of business necessity that have been argued before. Vocational degree is necessary to perform duties. That seems perfectly reasonable. But the second requirement, clients trust men more than women for technical issues. That would not be a legal business necessity. And even for number one, many cases have shown that there are exorbitantly high education requirements, and those education requirements often lead to a discriminatory impact on minorities, women, people of different national origins, simply because of their access to that education. So the question, this begs the question of how much of a discriminatory impact does the policy have to have? And this is tie back my point on South Korea and Indonesia. We have what's been established through case law interpreting disparate treatment by the Civil Rights Act called the 4/5 group. And so if there's a 20% gap between the majority or the non-protected class and the protected class, that is grounds for a discrimination case. So this threshold of a gap of 80% or more, the idea is that it shows the difference between what I call, I haven't coined this phrase myself, but I call it naturally disparate impact. Similar, to speak in economic terms, we have what we call perfect employment. Our goal isn't for everybody in the country to be working, to have a job. There's a third certain threshold in which we say the unemployment rate is perfect. And that's been determined through statistics that 20% gap is evidence that there's a causative effect, whether intentional or not. A causative effect between policy and discrimination or equal treatment. So you may all be asking, why am I explaining American law when we're discussing gender discrimination in Indonesia and South Korea. And the reason I bring this up is that it's very difficult to determine whether or not there is gender discrimination in employment, and whether or not there's been an appreciable effect on the legislation and some of the jurisprudence that has happened based on that legislation. So what I did in my research is I applied before fit school to the wage gap between men and women in Korea and Indonesia to see if there's a statistically reliable way. Most of the research I did came back and said that there is a wage gap, and then people gave various accounts of whether or not this was caused by intentional discrimination or whether it was just purely natural. And the gaps I came up with in South Korea, 2008, the wage gap between men and women was at 38.3%. 2016, it went up to 38.8%. The difference between men's wages and women's wages. In Indonesia, similar, smaller gap, which surprised me actually. 31.3% in 2008, and that went down slightly to 30.8%. And so my findings, I guess, based on the fourth fit school, is that this is evidence that there is causative or intentional discrimination in employment against women in South Korea. The question I did not answer is why. And in fact, I think it's partially culturally insensitive to say that this is injustice at all. To say that women's roles in society and in the workplace is that truly an injustice? And so I stopped short of that because I believe that would be opposing my Western values on a different society that I've only been somewhat familiar with. So it is interesting, and I think there's opportunity there to look at laws in Indonesia and Korea through a different lens. Whether you look at it more subjective or objective. So in conclusion, although there have been efforts made, for whatever reason, those efforts haven't appeared to make an appreciable impact on the wage gap that has demonstrated intentional or causative discrimination against women. So it was a very limited paper. Those are the conclusions. Thank you very much.
Thank you. Thank you, Professor Cation. His presentation is also very interesting, and his analysis is very persuasive, reviewing the current legislations of and the situations of Indonesia and Korea. Then the third and the last speaker will be Professor Buddhist Daryanto.
Thank you very much, Professor Choi. Assalamualaikum, Annyeonghaseyo.
good. Yeah, thank you. So actually, I'm not a professor, but maybe in near future I will get a professor degree. So I'm still a young teacher in the Faculty of Law, Islamic University of Indonesia. So it is an honor for me. Thank you very much for the opportunity to speak before the participants for the DILA International Conference 2018. Actually, especially for the participants from Korea, because my family, especially my mother, grandma, and also my daughter, my wife, loves about Korea so much. So they like the Korean boys band, also Korean romantic drama movies. Even they call me Oppa. I don't know what does it mean. I think after the session, I should get explanation from Professor Choi about the meaning of Oppa. Yeah, because I'm the only man and the young man in the family. I think the older one. So I'm trying to fit with my presentation about the refugees situation in ASEAN countries. But however, it's still under construction and I'm not ready to present about that. So I would like to present another research, but I'm so sorry that this research is a little bit different. I think it's not little bit, it's far more different about with the topic written down in the schedule. So this will be about the unmanned aerial vehicle or drone, and then how does it should be regulated under the international law. So, uh, so now we understand that the technology of war is growing so rapidly in the 21st century. And more developed states are building the technology, the advanced technology, just to make that the war should be easy to and also accurate to shot the enemy. But however, in the practice, there are a lot of violations of international law. So let me give you a brief explanation about the development of drone or uh, unmanned aerial vehicle. So now the type and the size and even the structure of the drone could be different. And maybe in the picture you will see that each drone having the big size, but in the practice, even now they develop. Yeah, and then you will see that it can be just like an aeroplane. So someone could control the airplane, and it contains the lethal ammunitions. Then also even bombs, small bombs, or maybe nuclear power. So, but this is also dangerous for the civilians. And also, they some states also develop the autonomous weapon, just like robotic movement with which contains the lethal ammunitions. So, and even the smallest thing drone, maybe we can see it from my from video that I get it from YouTube. So you can see that it was last year in 2017. I was in a conference in Budapest in 2016, and then one of the professor from Hungary developed the drone, and it has a very small size of drone, and even though there has no munitions in the drone, but the effect of the crash between the drone and the human brain, it will be made the enemy or maybe the victim could be dead shortly without any suffering. So you will see that it's so advanced and maybe the development is quite massive right now. Even at home, last time I brought the drone, but without any munitions. I brought it from AliExpress.com just only for 12 euros. So it's cheap actually, without munitions, but for only for camera, it contains the camera, it can take you picture or video somewhere around in the air. So the impact of the drone, even for the smaller side, it could be dangerous for the human being. So I would like to give you more videos about this, but maybe you can search it to you.
That is an airstrike of certain.
So what is my concern? Actually, the development of the technology on board is guaranteed under the current. It was guaranteed by the additional protocol 1 of the Geneva Convention, or maybe under the international humanitarian law rules and norms, that the study of the development of the acquisition or adoption of new weapon, means of or method of warfare, high contracting party is under an obligation to determine whether its employment would, in some or all circumstances, be prohibited by this protocol or by any other rule of international law applicable to the high contracting party. As we understand that, based on my research, there are around like maybe 7 countries still not ratified this additional protocol. The 2 of the states are United States and also Israel. Unfortunately, Greece, I should say United States for the first time now. Okay, so this is the states. These 2 states are developing the technologies. So actually, the question is whether they should also comply with the under the perspective of the international humanitarian regulations or not. But if we take a look on the development of this technology, it contains specific characteristics. The first, it can be multiple aircraft. Maybe it can be 2 aircrafts, but they can unite each other in the air. And maybe they can even spirit each other in the air. But the both of the aircrafts have a different function. And also the second, a flight control station. Maybe some military army, they establish a military station, and it has radio control to control and to play the drone during the warfare. And also information and retrieval or processing stations. So this is also the station to collect the information. And also in some cases, will land vehicles that carry launch and recovery platforms. Sometimes maybe they are not just like aircraft, but they are employed in the land. So this is also another type and characteristic of the aerial vehicle systems. And also the impact of the use of drones. Based on the scientists' prediction, the development of the drone itself, we can find it into various websites about the information of the development of the drones. That the first, the advance of navigation system could weaken the enemy in precise shot. So they say that the drone technology has precision, so they can even launch the munitions in a very precision to the enemy. And then second, rapid and detailed information system could reach the target without sacrificing the civilians. So the drone itself developed with the way that they can able to access all informations that if they can differentiate between civilian or combatant. And then the third, unmanned aerial vehicles is made to reduce the impact of losses by the combatants. So, because they do not involve the combatants in the field of war, but the combatants just only controlling with the remote or something in the station. So there should be a minimum losses from the combatant, from the military army. And also they said that this is more efficient than deploying military army to combat in the war field. However, most of the strikes are happened in Pakistan and Afghanistan. These 2 countries are part of the ASEAN countries. But certain strikes deployed in Libya, Iraq, and also Yemen. And more, I got this information from the report of the from the website, and then but there should be. I got the conclusion that each year the deployment of the drones and the strikes by the drones is increasing every year, and also the casualties, the victims, the effects of the strikes also usually more than 70% are coming from the civilian, the non-innocent people. So they said that they have precision, accuracy, and also collect all information from the field. But in fact, there are a lot of victims coming from the civilians. So we should taking into account that there should be regulation regarding how to use the drone in the war field. And also, based on my research, I found out that in the international humanitarian law, there is one principle that should be considered by all states in the world. The first is the only principle that I taught to this paper is about proportionality principle. The development of proportional principle is coming from 1949 from the case of Naulia case between Portugal and Germany. This case giving limitation on the proportionality principle, giving the definition of proportionality principle that it should be there is a prohibition to abuse the human rights. And then in 1975, the Article 51 of the Additional Protocol 1 also regulated about a specific prohibition. So an attack which may be expected to cause incidental loss of civilian life, injury to civilians, damage to civilian objects, or a combination thereof, which would be excessive in relation to the concrete and direct military advantage anticipated, is prohibited. So this is a big rule under the Geneva Convention. However, in the Rome Statute as well, it also regulated in Article 8, verse 1, paragraph 1, point B, 4, intentionally launching an attack in the knowledge that each attack will cause incidental loss of life or injury to civilians, or damage to civilian objects, or widespread, long-term, and severe damage to the natural environment, which would be clearly excessive in relation to the concrete and direct overall military advantage anticipated. So I consider that, yes, maybe every state has their own right to create, or maybe to create the technology in war, but there should be a fixed regulation, or maybe there should be a clear regulation in deploying even for the drone and also the autonomous weapon. So whatever the regulation, it should be considered the principle of proportionality, and I try to make specifications how this principle could be implemented for the using of the drone and also the autonomous weapon. First, that it must be all the technology in war, it must be protect the civilian under the protection of the civilian that was protected by all the international humanitarian regulations. So there should be civilian immunity, that the technology should not be used to kill the innocent persons. And then second, controlled by human. Why it must be controlled by human? Because the technology itself, even though they create the A1 technology right now, last week, Mark Zuckerberg is trying to develop more A1 to make surveillance on the hate speech in the Facebook. But the technology is still far of the precision, and also it must be developed more and more in near future. So whatever the technology, it must be controlled by the human. And the human itself, in this point, it must be military army that has been trained, and he can able to differentiate between civilians and combatants. And the third one, even though the technology has an accuracy and precision, but it must be not autonomous. So the autonomous weapon means that the robot or maybe the drone itself launching the attacks or strikes without any consideration, or maybe the robot itself collect the information by himself. But now we understand that all technology even has its own weakness. Just right now, even the technology, I can say to my phone, for example, this is the A1 technology. I don't know about the accuracy, but we will see on Monday. Just let me speak to my phone. Hey Siri, what is the weather on Monday? So it says that on Monday there will be no rain. It's just thunderstorm, so be careful on Monday. We will go to Borobudur. So we will check whether there will be rain or not. So this is the A1 technology right now, that developed by some all technologies, even that we are using the A1 right now. And then the last one, the command report. So there should be a command responsibility that the attacks and anything that launching the attacks should be under the responsibility, and it must be protected by international humanitarian law, procedures, and regulations. And the last one, all the technologies, even though they made in the very rapid and advanced technology, it must be respect the international humanitarian law. And also, I also noted in my draft of my paper that in future there should be a kind of regulation like in trade arms treaty, that all the drones using for the military army, it must be controlled and monitored by certain international organization. So I think that's all my presentation. Thank you very much, and I enjoy Yogyakarta. I would like to give the time to the moderator. Thank you.
Thank you, prosperous future Professor Tochi. Yeah, his presentation was very insightful and instructive. Yeah, he explained to us the two things. One is the legal basis in the development of new weapons, and the other is the impact of the use of drone. Whether the use of drone is prohibited or not in the current international humanitarian law. Thank you very much again. And now it's time for discussion. We have maximum 30 minutes for discussion. So floor is open. When you take the floor, please identify yourself first. And is there any questions or comments?
Thank you, Mr. Chairman and ladies and gentlemen. I would like to ask Professor Chris for the question about discrimination. And it's not because I'm a woman, but because the discrimination issue is indeed very public. So with regard to the ratification of international human rights instruments, Indonesia ratified many international human rights instruments, especially with regard to discrimination. We have ratified CICAO, we have ratified ICCPR, ICSPR, and so on and so forth. Compared to any other ASEAN countries, we ratified the most. But the question is, why discrimination is still happening in Indonesia? Sometimes I wonder whether ratification is only just formality, because in reality it is not happening, because discrimination is very massive, like what you have explained. I would like to ask what kind of solution that we can offer to help these international human rights instruments can be implemented fully in Indonesia. I would like to ask the best practices from the United States with regard to civil lawsuit, because discrimination sometimes can be solved through civil lawsuit. But in Indonesia, sometimes civil lawsuit is hard because the victim is not realized that she is a victim. It's also a matter of culture there. So I think from that argument, I would like to ask what kind of solutions that Professor Chris can offer. Thank you.
Okay, another questions or comments? Okay. Professor Lee.
Yeah, I have a very good question to both. Yeah, it seems to me that the Islamic concept of the life application you explained to us, is that also applied to the sea, the ocean, when Islamic law applied to in terms of the jurisdiction or expansion of the area, the sea area? That's the first question. And the second question is that when Islamic countries disputed over the territory, is that the concept you indicate us that apply to in terms of the dispute settlement? That's my second question.
Any other?
Thank you. I have questions for each of the presenters. First, Professor Priyanka. I think I'm making a similar question with Professor Lee. However, it is slightly different, therefore I will make the question. Well, it was a great presentation, and it was very interesting to hear the ideas in Islamic law. However, if I'm not mistaken, please correct me if I'm making mistakes. Those are private. It seems like there are private law analogy there. Could you distinguish the public law aspects in acquiring territories as well, or that in the Islamic law there were no distinctions between private and public law? That's the question that I have for Professor Priyanka, and I have a question for Professor Kason. It was very interesting to see the wage gap, and I was just wondering if some other factors such as career discontinuity in Korea, that's a huge issue in Korea in terms of discrimination against women, was also counted and reflected on those the statistics, because some argues that there are differences in wage gap because of women's career discontinuity. Because of their lack of experience, their needs are discriminated somehow. And I consider there's a multi-dimensional issues involved in this matter. Thirdly, Professor Dodig, I have a question in regard to artificial intelligence and banning lethal autonomous weapons in the United Nations. If I'm not mistaken, there are some resolutions in the United Nations going on. And could you give us some new ideas, not ideas, the news from the United Nations, what's going on there, what are some resolutions they're making on, things like that? Thank you.
And the next is Professor Singh.
Yes, I have one question for each panel speaker. I have one question for Professor Agus. And you mentioned one of the ICJ cases dealing with the territorial disputes among Islamic countries. You mentioned the case on the digital and products as an example of how the Islamic views on international law could be applicable to some of the dispute settlements, dispute resolutions among Islamic countries. But I'm also curious to know what your view is on the other case that involved the Islamic countries like Indonesia and Malaysia, and it's hard to call that Islam country like Singapore. That is the case of Pedra Branca. And in that case, the ICJ came to a conclusion depending on which territories they were dealing with, especially in terms of Petra Blanca. They call the Singaporean argument that some of the government function they exercised were good enough for the theory of prescription to take effect, thereby just government is already acquiring that territory with the application of the theory of prescription. While at the same time, the ICJ also said that in the case of middle rocks, they didn't find any evidence that the Singaporean government acts of effective control were not good enough or good enough to take those areas, those maritime features from the control of the Malaysian government. So they just let the sovereignty stay with the Malaysian government. So depending on these two different treatments of the territorial disputes by the ICJ, how would you say the outcome might be different if you were to apply Islamic principles of acquiring territories based on the revival of respect? That is my question. And a question for Professor Kaysen is whether those statistical evidence showing the income gap between women and men in the Korean context is based on the aggregated number of all the job categories, or did you focus on specific job category that clearly showed the disparity between the men's income and the women's income? It's just for the clarifying purposes. And the third question is directed to Dr. Dudik. You mentioned the importance of retaining human control in deploying and exercise and deploying the unmanned aerial vehicles and other technologically advanced weapons. So, but I'm also curious to know whether human errors could also be just as significant as the errors that we can get from the application of artificial intelligence or autonomous judgments by the robots and computers. So I'm just wondering whether you would see more possibility of casualties when we deploy the autonomous weapons and other AI-based weapons compared to relying only on humans. And I also was wondering whether what you said while describing the casualties by the deployment of UAVs were consistent with what you showed us in the graphs. For example, you mentioned that the casualties of civilians were kept on increasing by, but then maybe I was not taking a close look at the graphs, but one graph clearly showed the decline in the number of casualties of civilians by the year of 2012 compared to 2011. And then you also mentioned that the casualty kept on increasing, especially in terms of the civilians. And one of the graphs that you showed us was clearly demonstrating the zero number of the civilian casualties in the year of 2012. So I'm just wondering whether what you described was consistent with what you showed us through those graphs. But that's it.
At this time, so many questions has been raised. Can you remember all the questions? Yeah, okay. There are 2 or 3 questions for each speaker. So the first I will give the opportunity to respond to Professor.
Okay. So thank you. Your questions were both insightful and tell me you were paying attention to my presentation carefully. If you don't mind, I think I'll answer the second and third question first about the statistics and the contributing factors. So first of all, just as a point of clarification, in the paper, the statistics are broken down much more carefully. However, just as an example, these are the aggregated wage gaps. And they're simply aggregated by the Asian Development Bank, research that the Asian Development Bank did on, and it's truly raw wage information. It doesn't adjust it based on job categories. There was a lot of information on women's employment rates in different job categories, but it turned out that that's too subjective in how it's what kind of job categories and how the job categories are broken up, and so the experts in this field have identified wage disparity as the best indicator of disparity in employment treatment. And so we use the same lies, damn lies, and statistics. So also, it doesn't take into account the why. Again, why are women paid? Why do women earn less in these two nations? And let me clarify, it also doesn't, it's not that women are getting paid less for doing exactly the same job. It's basically saying that women are getting paid less because they face reduced opportunities for jobs to pay higher wages. And again, one of those factors is career discontinuity, in the sense that women who take leave for extended periods, family, etc., often have a gap, and so they're behind the curve, so to speak, for their. But again, that would also take into account their age and career level, etc. And so also notice that there are laws that remedy those things too. Pretty specifically, I know has a law allows men to be paid more for fresh graduates because of recognized military service, or that practice has been deemed legal. And so I know the reason I chose this analysis, the 4/5 analysis, is that it assumes that all those naturally occurring things, choices women make versus choices men make, cultural differences in who has the burden of raising children, for example. The theory behind the 4/5 rule is that if that gap, that disparity exceeds 20%, it's not just those natural factors. It's not just naturally occurring. And I would agree, I would argue further that if such a law was to be passed in Korea or Indonesia, that 20% threshold would probably have to be adjusted, because the naturally occurring gap may be different in America versus Indonesia versus any other country. So how they arrived at that statistical number was based on a compilation of statistical analysis over years and years and years of litigation. I think again have to be adjusted differently. But so that threshold is designed so that a plaintiff doesn't bear the burden of establishing all those other cultural elements. actions from disproving that it wasn't natural. Again, the defendant, or to say that it was naturally occurring or that there was a reason for it, it's a rebuttable presumption of discrimination rather than statistical proof. But I think as the statistics bear out, it's the presumption has been raised, or it's a rebuttable presumption, but it is, I think, a statistically supported presumption. To answer question number one, what do we do about discrimination against women, minorities, etc.? Of course, America doesn't do it better. And I always hate to talk about American laws versus Indonesian versus culture because it often sounds like we know what we're doing and other people don't type of analysis, and that's absolutely not true. I think the biggest reason why in my research for what are the laws in Indonesia, and what are the basis for anti-discrimination in Indonesia and South Korea, the starting point in all of the literature I reviewed was that the Constitution of the respective countries guarantees equal treatment, and then the treaties that the nations are parties to guarantees equal treatment. However, the devil is in the enforcement and the ability to seek redress for a violation of those things. And those mechanisms don't seem to be refined. So what is, if your constitutional rights are violated, or the government policy or a employment policy that violates the treaties to which the country is a party to, how do you seek redress? What's the mechanism? I know in Korea there's the Human Rights Commission, similar to our Equal Opportunity Employment Commission, and they adjudicate. But it's more of an administrative adjudication rather than a judicial adjudication. It's redundant. So the practice is basically giving laws teeth, meaning how can the anti-discrimination provisions that are already in place, how do people who don't have the means, can't hire an attorney, can they get it? How can they seek justice or fairness? And one of the ways that it happens in the U.S. is, of course, paying for attorney's fees, and giving greater access to advocates. The way the process works is that they have the right to sue after an investigation, and if they're indigent, the government will pay for an attorney to sue an employer for discrimination. Or they can recover attorney's fees and sometimes double damages plus attorney's fees. So those are some of the mechanisms. It's not about the laws that much different. It's more about the mechanisms for enforcement of the law. Hope that answered questions briefly.
Secondly, I asked Professor Ayanta to respond within 3 or 4 minutes.
Okay. Thank you for the chairperson for giving me opportunity to respond to the questions, and I'm so grateful for the curiosity from the participant here to discuss further on the issue of the land acquisition from Islamic law perspective. The first from Professor Sigmuri, the question as regard to the how as the analogy can be made for the ocean, I mean for the sea. Yeah, to be honest, that I'm not really in detail to what Islamic concept or Islamic perspective on the law of the sea, because this is not much developed compared to the land. I think the answer is because the context or the situation in which Islamic law developed is in the Arabian Peninsula, in which the desert and the land, and very far from, the sea. And I tried to search in, Islamic law references in classical, and I didn't found, mostly discussing online. But I read the book written by Professor Mary Hooker from Australia. He written Islamic law in Southeast Asia. And interestingly, the book discussing about Islamic maritime law, which was implemented in the era of the glory of Malacca Kingdom. Malacca Kingdom used to conquer the Malacca Strait, and they implemented Islamic maritime law. Though in the book itself, I cannot find the real content of what Islamic maritime law look like. But it was stated in the book that one of the legacy of the legal system inherited, by Malacca Kingdom was Islamic maritime law, which was implemented at the time. Okay, so to be honest, I do not really know in detail about Islamic law of the sea or Islamic maritime law, but this your question give me trigger to further discuss on this matter. Okay, and the question from Professor Sangmin Sim as regard to the separation between private and public, you are correct that Islamic law doesn't separate between private and public, but rather the most popular division of Islamic law is based on the matter like criminal law, we call it al-jinayah, and also business and transaction, we call it muamalah, and family law, we call it al-ahwal al-sosial. In family law itself, there are many criminal cases, for example, just domestic violence, etc. But it is under the division of Islamic family law. And also we have international law, we call it the Asia, and also constitutional law, we call it Asiasa. So the division or the separation in the aspect of Islamic law mostly based on the area which is not separated by private and public. So within public sometimes private matter, and also within private sometimes there are also public matter. But the point is that the differentiation, the differentiation based on the matter just I would mention before. And for Professor C. Jin Ho, that as Islamic law in the matter of land acquisition also implemented in the case of the dispute between Indonesia and Malaysia in the case of Likitan and Sibatan Island. What I presented in this paper is the Islamic perspective. So this is still the conceptual. I am not really sure that Muslim countries or Islamic State they implemented this, but the point is that we can search further aspect of Islamic law in order to contribute in the implementation of implementation and also for enrichment of international law. Because in modern state, as we say that Muslim countries also comply with the agreement, also with the statute, agreement and convention. and they ratified also the international convention. But this kind of point is permitted by Islam because one of the source of Islamic law is actually the custom or the agreement. The custom in Arabic we call it al-awrad. So the custom or agreement can be adopted into Islam as long as not contradicting with the principle of Islam. So in the matter of land acquisition, I think there is parallelism in which Muslim country or Islamic state do not necessarily reject this point because they are actually there is the similar spirit between the two. Uh, uh, but in the sifat and likitan, if we try to identify from the Islamic law perspective that the consideration of IGC at that time is about intention that the activities have been undertaken on behalf of the state and not private action. And this the proof has been found in Likitan and Sipatan Island. And therefore, according to Islamic law itself, the state who can necessary administrative activities or maybe any legal enforcement within the area, from Islamic perspective, they deserve for to gain the ownership. And related to the case of Singapore, I'm not really in detail about Batu Pahat dispute, but this is also not under Islamic law, of course. What I know, the dispute among or between many between parties in different countries, which can in which Islamic law may be adopted is in business and transactions, just like the dispute between companies in Bahrain, what I know is Samil Bank of Bahrain and Pexmico Pharmaceutical Limited in Bangladesh. They settled the dispute in the Court of London. But interestingly, the Court of London adopting Islamic law in business and transaction to solve the problem. Also, the dispute between some companies in Qatar and I forgot the other parties, but they follow Qatari law. I mean, the arbitration panel following the Qatari law, which is under Islamic law. But in the dispute in this land, I'm not so sure that they implement Islamic law until today. Okay, thank you very much.
Thank you, Professor Sim and Professor Wong. It seems that I have dissertation questions. Now, I wish that I have A1 tool that I can answer, that the tools can answer the questions precisely. So, yeah, there is no legitimate data in the field of the use of drone and the number of the casualties. But one that I got the data is coming from the internet, and also I got this from the specific website about the Bureau investigates. And then this specified the data, the using of drone by the United States and in Pakistan and other countries. In Pakistan, actually, there is based on the data, the CIA and the US military power used the drone strikes since 2004 to present, and there has been around 4,026 number of casualties. In my side, I think even though the number may be still not millions casualties, but the number, even though it's only 4,026, it means that the use of drones should not avoid the killing of the civilians. So there should be no number about the casualties in the practice. And I do also understand that in the development, the United Nations are trying to adopt a very specific regulations about how to control, how to make a specific regulation to the drone to be used in a very effective way and without any effect to the victims, to the humans and innocent humans. However, so far in 2017, there is only one negotiation, but no binding instrument so far from the international community. Now, I realize that we are facing with the international politics building the A1 and the military technology right now is we are talking about the business of the military technology. And who owns the business of the technology in military army? They are all developed states, and they are even not the parties, not signatory parties of the international humanitarian regulations. So we are also questionable the practice. Even if there is specific regulations, then we are still questionable whether they will also apply the new rule to limit the use of the drone to kill the innocent persons. And even if this is only small number, 4,000 only in Pakistan during 2004, 2018, then the use of drone and civilians should not be the target of the drone. So I conclude that there should be a specific regulations and there should be no fully autonomous weapon. And maybe in future, there should be mixed control between the A1 tool and also with the human. Maybe they can collaborate each other just to make a precision decision to kill the target. I think that's all. Thank you very much.
Thank you, Tony. Is there anyone who still wants to make? Yeah. If there is none, yeah, I declare the end of this session. Thank you again to all the presenters and the participants for their contributions made in this session. Thank you very much.
Thank you very much to the chairperson and all the speakers. Big round of applause one more time. Before we move on to the last session for today, we also have one more coffee break, so please enjoy the snacks and food. We will join you again in about 15 minutes from now. Thank you very much.